Overleaf at 33, your lordships will find, my lords, that very observation. If I can read 47, my lords. Thus from the, I'm sorry.
Page 47, para 47.
My lords, para 47, page 33, please, my lords. Thus from the above, it is clear, they are, my lords, analyze all the law and the colliery control order. Thus it is clear that post the colliery control order 2000 era, it is coal companies which can fix the price of coal, and the same position is affirmed by the Supreme Court in so and so, so and so. Please see the next line. The coal prices are no longer fixed by the government. However, they are subjected to regulatory oversight of the government. Government retains the power to regulate supply and quantity of coal. The question in the present case is whether...
Where is that instrument, document by which it is levied and collected?
87.
Well, it's this.
Where is that levied and collected?
Well, it's in the linkage order.
To become part of the landed cost of fuel. How does it become? That's my question.
Yes, please, Malaj.
That's our question.
There are only two documents for it, Malaj. There is the linkage order. I'm sorry. The linkage order, Malaj, which permits this linkage tapering to be given to them, itself specifies that the price of coal will be determined by the coal company which is being given to them. Your lordships may come, Malaj, to 469, annexure 17. My lords, kindly see the order is, my lords, by the Ministry of Government of India, Ministry of Coal, 469. Open it. Now please come to, my lords, 484. This is the standing linkage committee of the Ministry of Coal. At 485 bottom, please see, my lords, the last line after recommendations, etc. The rate for coal supplied against extended bridge linkage would be decided by Coal India Limited / Singareni Colliery Company Limited.
507.
And the same thing is at
Coal
5.
supplies as against extended bridge links.
Yes, my lord. And they are taking coal under a bridge link is admitted.
No, we are talking about, is there any specific reference with respect to the premium part of it?
No, my lords, that's why.
No
The
word
coal price,
premium.
I'll just, my lords, explain that. The coal price, which is whatever 100 rupees,
Coal price they are paying.
includes the premium, my lords. It's
That's
a,
what it is.
No,
it's a
no.
consolidated price.
Wait us.
My lords, the issue is
What's
this.
that? Just that. We are only concerned with the premium, right? We are only concerned. It's not that they are not saying that you.
My lords, in the
There
order,
is a
please see, my
premium
lords, in the
charge.
impugned
You
order.
may be right, but
Order chart,
you may be right, number one. Number two, whether it is inclusive of the premium
Where is he note?
and that was
Premium.
identified and looked into by
945.
the REC. Show us that.
Please see, my lords, page 46 of the impugned order. Please see, my lords, the premium that is applied by all coal companies on this. Please see 46
Everybody
bottom.
applies.
This is the note.
Yes, my lords. So there is Mahanadi and Coal India, my lords, at 46 bottom.
20%,
Page 46 bottom, my lords. In fact, they apply more than I apply. I'm Singareni, my lords. I'm state also 50%. Therefore, I'm 30%. Coal India applies 40%.
One page.
My lords, please see at the paragraph number 75 bottom. MCL is Manadi Coal Limited, CIL, my lords, prices notified on so and so. Please see the third column, my lords. Premium levied by MCL and CIL at 40% flat. Therefore, my lords, price in the next line. 1240, my lords, is the coal price. 496, my lords, is the premium. Therefore, the sector specific price is 1736. Please see next
So
page, my
therefore, the
lords.
only way you are relating it is that portion which you showed us just now.
Yes, freedom to determine price, my lords.
But then his grievance is about the inclusion of the premium.
Premium. My lords, for a minute.
Therefore, inclusion of the premium part of it, is it? So if the freedom means that you can add anything, then.
No, my lords, not anything.
So therefore, did the REC, just see how did the REC?
My lords, what the REC
Ignore
does is this. What, my lords, I'll just in 2 minutes explain. REC passes an order. What does the APTEL find fault with? REC passes an order saying, you are a coal company.
20%.
You also have a generating station. You are charging a premium on the coal. You should not charge a premium on the coal because the consumers in Andhra Pradesh should not pay more for electricity.
Page number.
Appellate Tribunal, my lords, on a legal point says, coal price is not determined by the REC or under the Electricity Act. Coal price is determined, my lords, by the Government of India under the Colliery Control Order.
To that extent.
And that price, my lords, includes premium by all companies.
That is exactly what we are asking you to identify and show us that the price will include means on what is the basis for identifying and levying premium. Is it relatable to what the central government does? If it is so, then show us that.
My lords, I'll clarify that.
That's the only thing we want.
My lords, there is no instrument
It
under
looks
which...
like, it seems also to be a general practice for everybody to.
My lords, it's like...
Everybody is levying.
Yes, please see the next page, 47, my lords.
Thing is-
In fact, Singareni is levying 30%, where Coal India is levying 40%. Now, my lords, second, may I give this illustration to myself with my lord's leave? My lords, there is railway freight for the coal to move from point A to point B. Tomorrow, my lords, it is like a generating company questioning railway freight, my lords, under an electricity commission. Electricity commission cannot determine railway freight. If railway says, I don't have,
No, they are, it is like, there's this distinction there. It is the charge which is levied by you on the basis of a central government notification or permission.
my lords, central government does not find fault with me.
No, it doesn't, that doesn't matter. But the question is that identifiable somewhere? That freedom, so far as the premium part of it is concerned. On what basis everybody is charging that
My lords,
premium?
the answer, my lords, is this. For linkages to be given, my lords, there is a coal linkage committee, my lords, by the government. Coal linkage committee decides that okay, Sajanpoy will get X tons, Raksha will get Y tons, etc. My lords, that linkage, my lords, is fixed for X number of years. There is a price of coal. Now, because a third party says, my coal block is not ready, give me some, in the interregnum, give me a
Where is,
table.
that is what we are asking you to.
My lords,
show us
that coal
lords,
committee minutes, my lords, are not here.
Where is
I can
that?
There's
produce
no
that, my lords,
document.
along with an affidavit. That's not here, my lords.
It is asserted that there is no such thing at all. And
May
everybody-
I answer your
on a
lordship's
pres-
question?
Yes.
My lord,
My lords,
he has a power to notify the price. CIL and Singareni and couple of other companies have a monopoly on coal. Keep that in the background. Monopoly on coal. Everybody is dependent on CIL and one or two joint venture companies like Singareni, which is Government of India and Government of Telangana. Now, he has a power to notify the price. I have included in the paper book an example of a notified price. At page 945 is an example of a notified price. Now, that notified price, he enters into an MOU, he fixes it and says, if I must supply coal, I will charge 20% more premium, 30% over the notified price. There's no authority.
It's what we are asking.
There's no authority, number one.
It's what we are asking.
Assuming he
No,
can
maybe,
charge
we don't-
premium, is the commission entitled
only
to
point.
review it?
He says there is no authority for the premium
my
part.
lords, that is because it's deregulated. My esteemed senior, my lords, knows that fully. Price of fuel, diesel, it is deregulated today, so there is no notification,
He
my
can
lords. from the
charge
ministry.
50%,
No, no, one
60%
minute.
and the commission
Therefore, my lords,
regulate.
when they take coal from me, they are free, and that coal procurement is also approved, my lords, by the commission. They are free not to take coal from me. They are free to wait for their block to be ready and then generate. Because they don't want to keep their generation facility empty, they are taking more expensive coal from me until their block is ready. Today, my lords, and it's permissible under the law for me to charge that 30%. The question, my lords, respectfully is, can the electricity commission say that commission is bad? No, the government of India can say. Have they challenged that 30%, my lords, by virtue of a writ? Answer is no. But in a tariff regulation, an electricity commission says the 30% you are levying Singareni because you're a coal company, you should not levy it. Even if you levy it, don't collect it here. My lords, that means coal going to them should go at 30% less. Same coal going to another generator will go at 30% more because that premium is applied, which is a discrimination. My lords, NTPC is
It's
paying.
not articulated anywhere.
My lords, it is, my lords. If your lordships, my lords, can kindly look at, my lords, paragraph number 85. My lords, please see 80, my lords.
At-
My lords,
Why-
kindly, 80, my lords, at page number 49. I will just read three paragraphs.
Why is it that in the APTEL also they don't really refer?
No,
85.
my lords, they deal with it extensively, my lords, from when my lords, pointed out to your lordships, para 47. Please see for a minute, my lords, para 43 onwards. They deal with it extensively, my lords, on 44, page number 30. Broad policy regime in coal sector with regard to fixing price of coal. Your lordships will find it at page 30, para 44. My lords, please ignore, they say Pallav refractory, etc. Please straight away, my lords, come to 1 minute. 1 minute. Lords, please come to paragraph number 46 at page number 32.
Charge any price and the commission.
Lords, in 46, please see, my lords, about 5 lines down. Post the colliery control order, coal prices were no longer fixed by the government, but were instead notified by the coal companies and are influenced by the cost of production, transportation, etc., etc. While the government of India does not exercise control over price fixation, it retains power to regulate supply and quality through coal. So I can't give it to them without a linkage committee. Now let's please see the
Even
next
with
slide.
respect to imposition of the premium, you are not bound. He said you have the freedom to fix it.
Freedom. My lords, I am applying this premium to everybody. That is also a finding in my favor. I do not distinguish it only for this generator. coal going
And
from
also, and also that not only you, other coal companies are levying.
the larger companies are levying more, my lords. Why do I give less, my lords? Because 50% of Singareni is owned by.
There's no larger company, my lord. It's CIL and Singareni.
It doesn't really matter. It's only you are saying right hand to left hand.
No, no. Singareni gives it to its own STTP, left hand to right hand. It charges a premium. It can do
Irrespective
what
of
it likes.
that also they can do it, right?
No, no. The question is, my learned friend is not answering the question. Does the commission have the jurisdiction under 86(1)(b
That's all.
to regulate the premium? If he charges a premium, can you regulate it under 86(1)(b)? Your lordships have held in two judgments. I'll show the judgment. The judgments hold that the commission's extensive power. Suppose he charges a premium of 100%. Please remember, he's a monopoly.
It seems to be
He's a-
across the board and
No,
applied.
across the
applied-
board and-
across the board.
It's across the
applied
board is a monopoly. It's a
consistently.
monopoly, CIL.
Please see
Doesn't
para
matter.
85, my lords.
No, my lord,
I'm sorry.
let me
I'm
complete
sorry.
my arguments. I'll have to show the judgments of Justice Gavai's bench and your lordship's bench.
That's okay. There's no doubt about it. We are clear about it.
The commission has jurisdiction. Now, commission says, I have
Not of
jurisdiction.
jurisdiction. Question is of the decision.
I beg,
Right.
I'll show the commission's order, my lord, the reasoning and the APTEL's order, which says is you have no jurisdiction. Commission says I have jurisdiction. APTEL says it have no jurisdiction. The question is,
Right, we will issue notice. It's a statutory
question of
appeal.
law is the jurisdiction of the
So
commission.
only because it's a statutory appeal, we'll examine it in little more.
Please, ma'am.
Issue notice,
ma'am.
issue notice.
It's a monopoly and he can charge
There's
100%,
nothing new about it
200%.
being a monopoly. There's nothing new about it, monopoly. That's
No,
the
no.
position all over.
Therefore, there is a commission. Because he's a monopoly, there is a commission. And 86(1)(b) empowers the commission to regulate a monopoly
There we
power.
are. Anyway.
You
take
know,
notice.
if monopolies are not
I think-
regulated, they'll do whatever they like.
Not at all. From 2017, this tariff is approved by the
Fixing
commission.
up that regulation of
That is
price
because for
fixation
3 years
is
you had
different from a regulation of electricity. These are two different things.
I'm grateful.
Anyway, pass. through. Issue notice. You are issuing notice. Mr. Notice, take a break, examine copies.
May it please, my lord.
Yes.
My lord, concurrent findings that my GPA was without consideration, that the GPA holder has transferred to his own wife at a deflated value only to defeat my interest. A High Court satisfied only on the basis that there was no prayer for cancellation of sale deed against my
Issue
lordship.
notice. issue.
Lordship, status quo as of today.
Status quo.
Lordship, and there's a delay of 58 days in filing the SL.
In refiling,
In filing.
notice.
Notice on delay, Lordship? Very well, Lord.
We will anyway condone it.
Great.
But then it should not be condoned with the absence ex parte.
Great.
Refiling we will condone, but otherwise.
Your Lordships, in item 21, I seek for a short passover.
Passover, what? Why? How is this MA maintainable?
Your Lordship, the council is engaged in some other court, sir.
Okay, Passover.
My lord, learned ASG is connected.
Similar matters we have granted leave, right? Same
Yes,
order.
my lord. As per the office report,
Yes.
identical. Grateful, my lord.
My lords, this is also statutory appeal. I am in a predicament, my lords.
Why, sir?
I was led by Mr. Sibbal, but last night, my lords, I was informed he cannot appear in the matter. So I wanted to seek a very short accommodation, my lords. That
I have no problem. I can put in my reply. Your Lordship will have it in January, my lords, in the meantime. Nothing's going to happen.
Have we issued notice?
No, first time coming up.
it's a fresh appeal, my lord.
Why?
Oh, my lords, I thought it's because they're pressing
Don't
for
want
stay.
us to dismiss it.
No, all right. Your Lordship may have it after, my lords. I think Your Lordship will have it in any date, my lords, for my lord's convenience.
Otherwise, it's a statutory appeal, my lords. May
Otherwise, a well-reasoned judgment, my lord, we've been suffering since 2017. Your Lordship may have it, my lords,
After vacation.
after vacation. Obliged.
I'm up.
That's purely on delay, Manoj. I'm against the SLP is against an order, Manoj, where my review petition is dismissed on
So
the
for
grounds.
defendant, right? It's a partition suit.
Defendant, Manoj, defendant in the partition suit, the civil court dismisses the partition suit. It is overturned by the first appellate court. I file a second appeal. My second appeal is dismissed because I did not file an appeal against the first order. Malas, there was no need to. It was in my favor. I was a defendant there.
But the
Please, Manoj.
the suit was virtually decreed in the first appeal.
No. In the
First
first
appeal,
appeal. So I file an appeal against that, Manoj.
that's your second appeal, huh?
That's the second appeal against the original order. My first appeal because it was overturned. The trial court order was overturned in the first appeal.
Delay.
Manoj,
A for conduct. A for dismissing. Delay पे क्या है second appeal?
Manoj,
Even otherwise. ठीक है, we should
I'm grateful.
notice.
Grateful. Deeply.
Here also there is a delay, 170 days.
170 days, Manoj. Manoj, this is Agartala, Manoj, and the petitioner has gone.
Partition suit also.
Manoj, the defendant number 5 was his father, Manoj.
After all, what happens and why do you want to knock away the property?
Manoj, I don't want to. I mean, my property is being knocked away, and what's been
It's a
happening is
partition
the
only.
execution is a separate cause of action.
Plaintiff is what to you? Brother?
Plaintiff is not my brother, not related at all, Manoj. I am in possession. So there were two aspects, Manoj. One aspect is that I had bought a portion of the land. The second aspect, Manoj, was that I was in possession, an adverse possession, Manoj. Now the partition suit itself is dismissed by the trial court. In the RFA, he overturns the RFA, the first appellate court overturns the order of the trial court. I am not related to the plaintiffs in any manner.
You wasted your time in filing all sort of reviews. And
Manoj, there was a waste of time, Manoj. There was a waste of time. I should have.
not worth it.
Manoj, that's the only land that I
Is there
have.
estoppel
Manoj.
against us.
The defendant number 5,
Let's take. What is this property? Where is it situated?
it's outside Agartala, Manoj. It's outside Agartala. It's about 100 kilometers from Agartala.
What's the nature of the property?
Udaipur, the nature of the property is agricultural land.
Agricultural land. Okay, notice.
I'm grateful, Manoj. Deeply grateful.
25.
Can a deemed license outlive the rejection of an application for license? Your Lordship held in my favor in the interim stage at page 170. Milord, application for license was filed. If not replied within 30 days, there is a deemed license. It cannot survive the actual rejection thereafter. After 2 months, it was rejected. Where is the question of a deemed license thereafter? Such a relief has been granted by the single judge and affirmed, which squarely against your Lordship. Your Lordship refused to interfere with the interim order. There was an interim order pending.
447(6) say?
447 says if no response, if the order on an application for any license or permission are not communicated within 30 days after the receipt of the application, as may be, or within such longer period as may be prescribed, the application shall be deemed to have been allowed. The landlord, second. Not stay also will
Stay.
oblige.
My lord, appeal against the relied upon judgments are pending, my lord.
Correct. Leave grant. Same order.
Obligement.
My lord, against the arbitral award, the writ was filed before the High Court. The High Court set aside the arbitral award and remanded back to the Legislative Council on the ground that on the day of award, the calculation was filed. In fact, my lord, on the day of award, calculation was filed for the interest, up to date interest. Claim was filed in 2010, 13 years back. And the parties have exchanged the affidavit. There was as many as 9 hearings. So finding of the letter of the High Court that on the day of filing the calculation, the award was passed is not correct, your lord.
Award. Arbitration. Let us have a look at that. Why do you say there are no reasons?
My lord, kindly see, my lord, the award at least, my lord. The award at page, my lord, 141.
What big award?
My lord, the award starts at page, my lord, 123. Entire history and the affidavit exchanged, the dates of hearing, all are mentioned. Thereafter, my lord, kindly come to page 141. 141, bottom para, my lord. On 30th July, only a
What reasoning you expect in in the grant of an interest? I say.
That's what, my lord. So what I'm saying, it is only a computation. The rate of interest is statutory. It is flowing from a statute. And the length of delay is not disputed. Only calculation was required to be submitted. That I submitted.
Interest.
And on the request of respondent, kindly see my lord, page 41, bottom para. 141, bottom para.
He's missing this fellow. Statutory entitlement. Profile. Still pending whether 226 is maintainable or not.
My lord, in
It's not
the
referred to a constitution bench.
my lord, my submission is that India Glycol is still binding.
Whether it's maintainable or not.
India Glycol is still binding, Your Lordship.
Therefore, repeat.
The High Court district-wise India Glycol following the Jharkhand Urja.
Mera judgment how this.
In Jharkhand Urja, my lord,
Notice.
my lord, the stay of demand, Your Lordship, the next hearing before the council
Stay.
is on 17th, Your Lordship.
Stay.
Grateful, my lord.
May I please, Your Lordship? Lordship, the present order rising from the Honorable High Court Guwahati orders, which declared the petitioner being 59-year-old as foreigners. The petitioner herein has its name recorded in the voter list of 1966, 1970, and 1980.
Omitted essential and most fundamental facts like name of the parents, grandparents,
Lordship,
siblings name, place of birth.
Lordship, in the written
Also,
statement,
High Court says that linkage is nowhere proved between anybody.
Lordship, in the written statement,
No evidence whatsoever.
Lordship, in the written statement at page number 39, the petitioner categorically has mentioned that the name of father of the opposite party has been recorded in electoral rolls of 1966 and 1970 as a regular voter. Subsequent in paragraph number 8 itself, the name of
The
the
certificate was a little exhibit P16. All what happens is that you're producing certificates and not examining, which is a big suspicion about whether those certificates are genuine.
Your
or
Lordship,
not.
it is the
You
admitted
produce
position.
a certificate, you must examine somebody.
It was not examined, Your Lordship, but the coordinate bench of this honorable court has on multiple occasions.
No, those are different. Each case on its own facts. We
And
have
Lordship,
issued many cases. now.
Lordship, the difficulty is he is 50. In fact, the citizenship of his father, his brother, his sister has not been challenged, Lordship.
But then why is it so? Why, if all the more reason that why is it that you have so bereft of complete facts? Sorry, dismissed.
Lordship, may I take your indulgence, Lordship?
No questions. Next.
She is 60 years old, Lordship. Of life.
29. 29 में letter है. Yes. Hey, इसका
Please, my lord. This is a case, my lord.
इसका husband.
Entire family, my lord. I am the head of the family. I came in 1965, my lord. Please, my lord. And status quo, my lord. I am grateful.
Wife रहेगा. बच्चे रहेगा.
May I please, your lordship? Just give me a minute, my lord, because a new category is arising for your lordship consideration, which would need a little intervention. So this order, my lord, it's only the refusal of the physical inspection. I'm coming to that, but there's something which is, my lord, now my lord, I'm obliged to bring it to your lordship's notice. Something, a paradigm shift which has taken place, and the approach has to be different. My lord, now if a long pending suggestion that the government hospitals which are not having colleges, there is never any problem of the clinical material, that is the patients for treatment. They're overflowing. Whatever is minimum needed, they are 5 times. Every bed has 3 to 4 patients, etc. Earlier, there was no collaboration of a private entity with a government college. Now there is a policy shift. It has been permitted. This is one of those cases where the private enterprise is permitted to collaborate with the state hospital. There, my lord, your lordship, I can, my lord, make a very humble submission. Never any issue of clinical material. The number of patients, which is the most important thing for treatment, is never there. Number 2, my lord, most of the changes are being done arbitrarily by various states and various authorities. For your lordships, remember, my lord Mridul, where time schedule are for two things. One, for your granting permission, one is for admission, and nobody would change it. Here, the states are now changing it on their own, and it has been extended up to 16 December in Jharkhand. And my lord, now I am told that the applications are coming before the central government. They may come up for further extension because a number of state seats are also lying vacant. They have not been filled up because the permission which should have been done in May have continued till December, the grant of permission. Here in this case, my lord, three cases came up before the Honorable High Court. In two cases, the physical inspection which was not carried out by them, which they were obliged to, was ordered to be carried out. And my lord, I am told yesterday
that your larger principle will consider, but then today the issue is about interim directions only. That is a different matter.
I'm just highlighting that. Three cases came up before the High Court. In two, the physical inspections are ordered, and in one, the High Court has rejected all objections that said permissions I have to grant, but now the time has gone out. I'll wait if there's any time extension. I'm only saying, my lord, your lordship may have it by Thursday. There might be applications coming from the government for extension. There are applications which are coming from the colleges. If, my lord, that happens.
But what happened? Your writ is pending in the High Court.
My lord, my physical inspection is not permitted. Whether I am considered this year, that year, why should I lose on physical inspection? You are chosen in 10 minutes on, say, I virtually inspect.
Problem arises because you are linking every time permission to start a college or year gets linked with vacancies and stray vacancies. That's the problem.
Let me, my lord, I bow down. I am just making how this impractical and arbitrary in this case. Essentiality certificate is to be issued by the state. One of the clauses is missing from the format. I had to get it corrected, your lordship. Now, how much time you require to persuade them that you please correct it? It is only that, my lord, on
what do you want today?
I want, my lord, your lordship, just
have it on Thursday.
Permit me a notice Thursday, and my lord, I am praying that if they consider me for inspection, whether I get it this year or not. And inspection means what? Hospital is not to be inspected, which is the most important consideration. Hospitals are not to be inspected.
But what are the other things on the basis?
Other case, essentiality certificate did not have clause. And the clause is...
Why couldn't you have made all this before the High Court itself?
I did it. I only wanted a physical inspection as the... kindly see 2 pages.
The High Court has not refused it.
No, kindly see page. No, only one thing.
This is just an adjournment order.
Just see 179.
It will be very unfair for you to even say...
Kindly see, 179. That is what I wanted to highlight. Kindly see 179 and 183.
Rest of the merits when High Court
just see
the case.
179. If your lordship will just give me this indulgence, 179. 2 similar cases which came up at 180 para 7. Physical inspection is ordered, and they are now, my lord, getting a permission only because of the High Court has now granted them that you fully, please see 179 and 180 para 7. It is for the last 3 lines. It is further directed and NMC shall carry out physical inspection. I only wanted that. And 183, second college. Physical inspection order.
Man, you are arguing as if High Court has rejected that prayer.
If the prayer for physical inspection is not granted,
ask them to advance it and then hear it.
Therefore, I am saying, Lord, kindly have it Thursday. If it is the time is extending, I will go back. If the time is extended, then your Lord.
List on Thursday, list on.
Lord, can I serve the other side?
Physical inspection if it can be done.
It's called the camel and the Arab. You know the story?
No. Lord, it would be easier, my lord, because
serve.
Yes, grateful to you.
Physical inspection in the month.
Against adjournment order.
Grateful.
We are being led by Mr. Uday Gupta. He is appearing through VC, my lord. We are being led by Mr. Uday Gupta, senior advocate. He is appearing through VC.
Wait, please, your lordship, lords. Here, my lords, if your lordship would kindly have page 78 and 79, which is the interim order dated 27 January.
There must be something called integrity of the examination, Uday.
Please, my lords.
Huh?
That is there, my lord. All that the High Court, yes.
You do. How do you want us to relax this position?
No, I am not asking your lordship to relax, my lords.
Semester without passing the first semester?
No, my lord, I am not requesting your lordships to do that.
Then?
All that I am requesting is, my lords, that she was ATKT, which is allowed to keep terms for the first semester. Now, that first semester, my lords, ATKT paper she has given in terms of the interim order of 27 January.
Huh?
Not ATKT is allowed to keep terms, which is in other ways a compartmental candidate. So she's not a failed candidate, but she's a compartmental candidate in one paper.
But
Now,
the
in
rule is that the fourth term can't be taken if you don't clear the all in first term.
Milord, that is what I'm respectfully submitting, that at page 78, 79, if your lordship would please come to the interim order, she was allowed to repeat that ATKT paper. The university was heard. Now, all that was simply required was, milords, the High Court, after this interim order of 27 January, should have just requested the university to declare the result, or at least show it to their lordships, milords, in the High Court. In case she had cleared the ATKT paper of first semester, milord, the fourth semester, in any case, she would have passed because she has appeared there. Fifth also she has appeared. Second and third, she has any case cleared, milords. All that was required was that. And that is why their lordships, milords, while passing the interim order, said you can appear in your first semester ATKT. Kindly just see the second paragraph at page 78, which is that she submits that in similar circumstances, certain other students have been permitted to appear in the fifth semester examination who were carrying forward their first semester ATKT paper, which, milords, is correct because the university, in its response, written response to the writ petition, at page, milords.
Oh. No, this is the fifth semester, right?
Fifth, she has given under the interim order passed by the court.
Order, she was permitted to take the fifth semester.
Yes, so milord, but they did not declare the result. Neither did they declare the result for the fourth semester, nor for the fifth semester, neither for the first ATKT.
Because this appearance in the fifth semester was happened because of earlier interim orders.
True.
Then
No, milord, only one interim order. Milord. No earlier interim order. Only one interim order.
Considering the legality of the taking of the fourth semester without clearing the first. What do you say about that?
Yes, milord, that is what I'm submitting, that this interim order of 27 January allowed her to appear in that ATKT paper of the first semester. Now, in case, milord, she has passed that ATKT paper of first semester, which only the university would know. They have not disclosed the result of that ATKT paper. They have not disclosed the result for the fourth semester. They have not disclosed the result of the fifth semester. However, 1 year after this interim order, when the writ petition is heard finally by the High Court, they say,
What because
yes,
at the time you took the fourth, this is actually a red herring what you are arguing. By the time she had taken the fourth semester, now because of the interim order, you have gone to fifth semester also.
I'm not.
The fourth semester, did you pass the first?
Milord, first I have given as an ATKT candidate, which is also, milord,
To notice.
I'm grateful, milord. Milord, could I only request that if your lordship could have in the reopening week, we'll serve them Dasti, milord.
Yes, that's the in addition.
A reopening week, milord, so that her sixth semester, in case your lordships are inclined to, milord, set aside, then her 1 year will be saved, milord.
Has she, when exactly did she pass the first semester?
No, milord, first semester, milord, she is only failed in one subject. That is economics 1. Now,
that till not known whether she's passed or not.
That is not known. Had the High Court just asked them to disclose the result,
There
things
is
would
no
have been
doubt
very clear.
about the fact. There is no doubt about the fact that she did not pass it when she took the fourth semester. There is no doubt.
Milord, that is only in the knowledge of the university.
There is no doubt.
No, milord, I think she has passed.
Because of the interim orders, you continued, and now you want to say, anyway, we will issue notice, we'll see.
I'm so grateful, milord, so deeply obliged.
She would have passed.
Because this SLP is arising out of consent order without there being any.
Lottie, terminated. Advocate. Advocates, no consent, isn't consent saying. Why you are saying a consent order? No? It's a consent order, right?
But Milord, there was no consent.
No consent. That's what you are saying.
The order says us.
बाद में भी बोला नेक्स्ट पेज में नेक्स्ट में भी बोला अब भाई क्या है इसमें what is even otherwise also what remains the termination occurred in 2019. Your shop was sealed in 2019. What remains now? 2019, the shop is sealed. Fresh tender.
Shop was
You
sealed
are
in violation
permitted
of
to
PP
remove
Act.
goods. What's there in this?
There is no provision of sealing in PP Act.
It's all right, but then since when? 2019, the shop is closed. Take your goods and then move out.
In the goods, goods were goods were medicines, my lord. All expired.
Then okay, that's okay. Then nothing remains even now. So it was only a permission. But the order was to take it up on 2nd of February 22
Yeah.
and vacate. What happened? You never bought. And then you waited till that date and filed the review petition after 21 days. Infructuous virtually, dismissed.
Minutes.
34.
For the position of the assistant professor, the university has selected the respondent number 4, who does not have the essential qualification. She has not cleared the net, and her PhD was of 1991. The petitioner has a very brilliant academic record. He cleared his net twice in 2002, 2003, and he has PhD also. But respondent number 4. Respondent number
2010 selection, sir.
Yes.
You're talking about 2010 selection.
What happened, they did not declare the result. And I have stated this fact
What happened in the meanwhile? What is it?
I filed the writ petition.
2010.
I filed the writ petition. It remained pending. Then I was sent to the chancellor, and
Every stage you lost.
Your Lordship, kindly see, my lord.
The selection. See, what is
Well,
the
only two facts are necessary. Only two.
This case.
Please.
The selection of 2010 is over. Respondent 4 and 5 were selected.
They were not
now going to
kindly see, my lord.
Selections.
The respondent number 4 was my lord, allowed to join before the interview. It is most arbitrary in manner, my lord. They have, kindly see, my lord, their joining. The respondent the interview was held on 17th November 2010. And the respondent number 4 was allowed to join in August 2010, my lord. The whole selection is vitiated, my lord, by fraud. And this fact.
Too late. Thank you. Dismissed.
The delay may be condoned.
Delay. Thank you, Mr. Bengal.
Please, Your Lordship. Lordship, by the impugned order, the High Court, my lord, has allowed the revision petition. My lord, by the impugned order,
Only 2 lakh की मामला है.
High Court has allowed the converted, my lord, converted the, my lord,
equity. 2 lakhs, that's all.
No, my lord, what High Court has done in revision petition, my lord, in appellate court, this, my lord, petitioner, he was acquitted, my lord, in 3 cases, and in 1 case, the sentence was reduced from, my lord, 1 year to 3 months. Now, in revision petition, my lord, the complainant went in revision.
Mind you, settle it. Matter.
I'm willing, my lord, the complainant is.
This is hardly case. The High Court
my lord, this is a reportable judgment which High Court has made. It's, my lord, 401. He can't convert, my lord.
There is no conversion. This is completely incorrect. There is no conversion.
I'll read the operative portion.
In all.
1 minute.
Trial court judgment.
Restoring only. It is not.
Lord, I read the High Court order. Lord, I read the High Court order, my lord. He has converted.
It is. He is entitled to restore the trial court's order.
No, my lord, no. I'm due respect, my lord. No, he can send it back to the appellate court by saying he's remanding. Under 4013, he can't convert it, and he has converted it.
Notice. Will issue notice anyway.
And my lord, I am praying for.
Anyway, thinks of.
And I am praying for interim order, my lord. He will put.
Stay. In the meanwhile, why don't you?
My lord, I am saying that it can be remanded even today. Your lordship may see the legal position. I am not opposing, my lord, that if appellate court comes to conclusion that yes, he is guilty, he can do it. There is a reportable judgment, two judgment.
You want to argue all these cases just for 2 lakhs rupees?
My lord, I have paid him the entire.
13, both of you.
My lord, he was my neighbor. I had taken money. We were transactions. I paid him entire money. He had taken my lord security papers of my plot. He sold it to somebody else.
I'm not going.
I'm not going.
Merits of the matter.
My lord, I'm not going.
If you want both of you settle it and then close it, I think with the good offices of both of you, your party, you can bring peace to the party. Is this a case where the These people should fight for so many years. From 2009, they are fighting for just 2 lakhs of rupees.
indicate that, my lords, we are willing to do it, my lords. My learned
Just
I'll
2
do it.
lakhs of
I'll
rupees
talk to
is
him,
not
Milord.
fighting.
I'll talk to him. I will do it. We'll do it. There's no issue. But he should not be sent to jail now.
You're not. Just settle it. Whatever is there, you just
Lord-
pay and then.
Lordship, yeah, I'll
Give him some. Give him. Don't get into tell your client not to have ego hassle. Give him something more. and
I'll definitely persuade him, Milord. There's no issue.
Else we will restore it, and what will happen? There's no end to it.
Milord,
Will we refer it to mediation?
Yes, yes.
Milord, Lordship may just give me one chance. On the next date, if without going mediation, we can sort it out.
Notice, Learned Counsel for the petitioner shall take instructions for referring the matter to mediation. List on. Take it up on Friday.
Milord,
how long we'll pass it over, call it, and then ask him.
Milord, January, Your Lordship, will keep it. There's a marriage. There's a marriage in his son.
Even without asking, just we'll pass it over. Ask him whether he's interested in settling the matter, or you interested in litigation. Then we will grant leave and then keep it pending.
As Your Lordship, please. Milord, only
out.
Lordship.
We'll find out.
I'll find out, Milord. Lordship,
We'll pass it over.
No, not today, Milord.
All right.
Right.
After vacation.
Milord, I might pray for an interim order, Milord.
We will not issue notice. We'll post it after vacation.
Lordship, the interim order, Milord.
In the meanwhile, that he'll take instructions about referring the matter to mediation.
Grateful.
Great. I must, my lords, my learned friend is here, my lords. I must say that I have no intention, my lords, to send him to jail as such.
Notice or stay hoga?
I'll accept notice, my lords, for the complaint. I must say, my lords, I have no intention to sending him to jail as such.
You understand? Then all the more reason.
Yes, my lords.
All the more reason. This is hard.
My lord, my learned senior can use it.
Both of you can sit and then finalize.
Milord, I'll ask him. I'll talk to him. I'll tell him they're definite.
Right.
Great.
Help your clients, both of you.
Great.
Yes.
Your Lordship, this contempt petition was rejected on limitation, and Your Lordship, I agree that we are not good at the point of law here. But Lordship, he is Mali and uneducated person, and this happens all the time in the service matter that a person wins case in the High Court and without contempt and and he does not even know that contempt exists.
Not at all. Thank you. Dismissed. Next.
I'm seeking a short passover with item 37.
I'm appearing for the respondents, Lord, in this matter.
Mr. Sibbal is leading me, Milord.
Yes, Mr. You are the only one who has taken the option of not coming to the court. And
Lord, I'm not actually not well because of this pollution. I'm actually having a lot of cough today.
Risking your lives. Regional consumers are. What happens to this?
Because I'm seeking a short passover, Milord. Mr. Sibbal is on. Grateful.
He wants a passover. Is it okay, Venkatesh?
Yes, Lord.
Excuse me.
Lord, there is one thing I must point out. Your Lordships had indicated him to deposit the amount, but we had made a specific request and Your Lordships in fact had acceded, which is not reflected in the order. That deposit at the rate of 10 from the date of the decree. Lord,
has he done that or not?
He has deposited from the date of 2015.
How much has he deposited?
September 2014.
How much has he deposited?
Lord, the difference comes to about 1,24,000 and odd.
कर लेना हो जाएगा.
Yes.
Do it. We'll adjourn it. We'll have it after vacation. You deposit the remaining.
Yes.
We'll close it. Huh?
We'll also be requesting for Milord permission to withdraw, so that
we'll do it. We'll dispose it off.
Yes.
Let him, because why again?
Yes. I will give the table to him so that Milord he can
deposit that little amount and we'll dispose it off.
Please.
1 minute. Huh?
Your Lordship, I'm requesting for a short passover.
My lord, I'm taking it down.
Yes.
My lords, Mr. Adi Narayan Rao is leading me, my lords. He is not available today, my lords. So he'll be there on Wednesday physically, if my lords may kindly keep it on Wednesday or maybe after.
Hey, everyone is appearing online.
That's my lord. He is, I mean,
Not six, obviously.
somewhere else, my lords, appearing. So if it may be after vacation, my lords, he'll be there. Because I don't want him to come, my lords. Here.
Immediately after vacation, my lord, if any short date maybe.
Date is an argument.
Obliged.
Yes.
Grateful lordship.
Milords, I appear for respondent in item 40, Milords. We need little more time to the instructions to take instructions from BCCL, Milords. And my lords will recall the last occasion my lord had asked us to seek instruction from BCCL. So we'll take a little more time, Milords.
At the request of the learned counsel for the petitioner, respondent, right?
Yes,
Respondent.
At the request of Mr. Amit Sharma, adjourned by.
Milords, may keep it in reopening, Milords. Reopening first week January,
We'll
Milords.
see.
No difficulty, Milords.
3 weeks.
Grateful.
Grateful, Milords.
May it please, Malats. Lord, I appear in 41.1.
Power of
Malats, this is that forfeiture matter, Malats. Post the LOI for the next 1 year, he does not get the environment clearance to start mining operations. We had taken out a tender for e-auction of a sand mining lease. Was the high
exist? Will the LOI amount to a contract?
Yes, now
And
in Parliament, it will come.
Parliament.
Your Lordship, kindly see these paper in Parliament. This whatever Your Lordship put the question on last occasion, put the question before the Parliament and answer. And once lease is executed, then it is contract. Your Lordship, kindly. Your Lordship is right on that.
What has Parliament got to do?
Well, in any way,
Why are you citing Parliament debates to us?
In any way, on the judgment itself, has considered each other.
Shows the LOI.
Malats, the LOI, it is at page, it starts at page, Malats, 37.
Power of forfeiture.
Yes, Malats. It's under Rule 29 of the Uttar Pradesh.
29.1. Where is 29.1?
Malats, 29.1 is reproduced in the impugned order also, Malats. If you, Malats, is pleased to see the impugned order at page 3. In para 12.
Forfeiture कर सकता है नहीं कर सकता है.
Page number 3, Malats.
Page 2. Page. Page. It's a page itself.
Rule 29 is there.
No, forfeiture इसके समय हो सकता है क्या? 27A. 29.1.
29.1, Malats. Page 4.
The successful bidder tenderer, after receiving the letter of intent of the concerned e-tender auction, e-tender and e-action shall produce before mining plan and clear environment prescribed as per the rules. So the same will be executed from. So the registration of the said lease deed will be registered in 3 months. The period of lease will be. What is there in this?
Malats, in our respectful submission, Malats, 3 months is the time that is given to the highest bidder, the LOI holder, to bring in all the necessary approvals for executing the mining lease deed.
That's right.
Yes.
Upon non-compliance, will it entitle you to forfeit is the question.
My lords, may
Yeah,
please
how to
see the last 3 lines, my lords.
Just read that.
If due to fault on the part of the leaseholder, registration of the said executed lease deed is not registered within 3 months, then the said lease deed will be treated as null and void and the amount of security will be seized by the district magistrate. That is what we have done. What my learned friend did was, after the respondent, my lords, after the LOI, they got the mining plan approved.
This has not happened, no?
My lords.
If due to fault on the part of the leaseholder,
Yes, my
it
lords.
become a lease, then registration of the said executed lease deed.
My lords.
Have these two happened?
No, my lords. The 3-month period is the maximum time period for all necessary approvals. If my lords may see the first part,
It is not only for execution. It is obtaining the necessary approvals like mining plan, environment clearance, and execution. All three, my lords. Otherwise, this will be rendered. Then he can, my lords, then a successful bidder can sit on the mining plan or the environment clearance for years together, and I won't be able to do anything. But that cannot be the intent of the provision. The intent of the provision is you have got 3 months' time to take the necessary approvals.
We'll hear it. We'll hear it.
Very well, my lords.
But in this case, Your Lordship, kindly have page 2 of the judgment. Then at few paragraph, all the question has been done. Paragraph 9, kindly see.
In fact, on LOI, my lords, Bhushan is very clear. I'll produce
Not only Bhushan, but then this is it's not about LOI, it's only forfeiture.
But 20
Forfeiture is a very strict provision.
Yes, ma'am.
Read the judgment or take the judgment of televotes.
I'll look at it, ma'am.
Televotes, you can't. Forfeiture provisions have to be very clearly expressive and strictly to interpret it.
I will look at
televotes. After vacation for file and disposal.
Grateful,
Notice
ma'am.
gaya hai na? Notice has gone in this, right?
Yes, my lords. Readings are complete.
In respect of first installment and release to us, what not. Only Rule 29 is confined. Lordship, kindly see the order. Rule 29 is confined.
42. We'll hear you.
Please.
Some date may come.
Grateful, my lords.
Yes. What do we do?
They filed an affidavit day before yesterday, which brings on record certain orders, Lordships, as we'd mentioned, as I submitted before your Lordships. There was already an ongoing dispute which the District Cricket Association has not disclosed before the court. There were orders passed by the High Court, and there are observations in the orders which the High Court says that they filed a petition by suppressing facts, trying to amend the parties therein. So, Your Lordships, I think Your Lordships will have to hear it.
My lords, I have some strong objection to this affidavit, my lords. My lord, this matter is
To the application.
to the application which they have filed, my lords, for additional documents. Well, this matter is sub judice before the division bench of the Madurai Court, the Madras High Court, my lords. And now, my lord, this was never the issue. The issue in this petition was only with regard to applicability of Nitya. And secondly, my lords felt that there should be some mechanism for determining the membership. Therefore, the learned amicus had made certain suggestions. We have filed an affidavit accepting all the suggestions and the way forward. But today, all these issues cannot be raked up, which are sub judice before the court, my lords.
Yes.
Because
With
these are all
respect,
factual
Lordships,
matters.
Ultimately, even if Lordships are looking at Nitya and the impugned order in this case, the issue boils down to only one thing. What is going to be the composition of the members and what is going to be their voting rights?
We'll confine to that only.
That's right. My lords,
Yes,
kindly have
on
my
that
affidavit.
aspect,
I have
Lordships,
said so
my-
specifically because the objection was that there is only 1 year waiting period, my lords, for the new members to be inducted.
We'll hear it.
Then secondly, my lords, because
When do
this,
you want? When do you want?
my lords, as soon as possible, because my entire functioning has come to a standstill, my lord, because of this.
Lordships,
My lords,
keep it
any
What, second week of January?
non-miscellaneous.
On a non-miscellaneous
My
day.
lords, at 2 o'clock, if it is possible.
2 o'clock में लगा देना Tuesday खुलने के बाद. Second week Tuesday.
Grateful.
Note कर लो. Note it and then tell me.
Grateful.
Grateful.
Thank you.
Mate, please. My lords, department acts in a diffuse manner, my lords.
Mr. Vikas Shukla. Whatever needs, just compile with respect to submissions and then make necessary submissions, notes of submissions.
My lords, sir,
We
I
will
kindly
discuss.
request them to give me some advance copy because every time on the last minute this paper.
Amicus or?
No. The respondent.
They are bound to. You must supply. You must supply to them.
They gave it on Sunday. Yesterday afternoon they gave.
Give them in advance.
Mate, please, my lords. If a department, my lords, acts in a vengeful, vindictive manner, on 3/5/2019, initially an order is passed for not giving me increments for 3 years. I challenge that order before the High Court, my lords. That punishment is set aside, my lords. Then a new charge sheet, new show cause comes into place where I'm not, it's worse than the previous punishment, my lords. I'm suspended from service. Single judge sets aside that order, my lords. Then it comes to the division bench, which is reversed, and now I am before your lordships, my lords. How can I suffer a punishment that is worse than the initial punishment, my lords?
You have issued notice, right?
Your lordships have already issued notice, my lords.
We have filed a counter. Only thing that what has happened
a bit harsh on him.
Lordship, may I? May I just articulate what happened? It may
Then
overall
may I be
look
allowed
very
to argue my
innocuous.
case? May I be allowed to argue my case before my esteemed senior?
We'll put it up for hearing.
Lordship.
List for disposal.
Milords, I am
Lordship,
facing
most
dire financial.
Lordship, may give a short date. I don't have a problem.
I have
But
not
we'll have to
got
argue
any,
it out.
I've not got any
We'll have to
benefit.
set aside the order, right? If
Yes,
Lordship, it needs a little argument because I feel
we'll
that
have
it
to
was.
hear them.
Yes.
Milords, that
Prima facie, we are with you, but subject.
Yes.
your lordships may just
for
keep it on a date, Milords, where
Because what has happened is one person.
An early date.
Lordship, at your whatever
Next.
convenient.
if a date can be fixed, Milords, I just.
Yes, we will fix it.
I'm very grateful, Milords. I'm very grateful.
Deeply obliged.
Item 40.
Deeply obliged.
May it please, my lords. My lords, the seat in question was a backlog vacancy and the same was reserved for an ST candidate. My lords, the select list to the said backlog vacancy ought to have been drawn as per the Rule 6 of the special recruitment rules that the seat was a backlog vacancy. My lords, the Rule 6 provides a preference to the candidates aged between 29 to 40 years, even if they are lower in merit to the candidate lying outside the said age bracket. Whereas the selection authority, however, draws the select list as per general merit, ignoring the special recruitment rules. Resultantly, my lords, the respondent number 3, who was younger in age but higher in merit, got appointed to the sole post, even though she was outside the said age bracket.
On the 2001 rules to apply.
Yes, my lords.
You've already given a judgment on this point, which has become final now. State of Himachal Pradesh. Check that out.
My lord, in any event,
Service matter, huh?
doesn't apply
Service matter, old rules won't apply.
It's very clear. Even these rules, if my lord just has page 26.
It's covered by the judgment.
The unfilled vacancies are for what was unfilled in 2001. This is a 2016 appointment.
Sorry, dismissed. 45.
This is that. The vegetables.
Mr. Agarwala.
Yes, Manoj. Was what I stated on the
What
last
good
occasion
news
is
for
I'm
the other side?
willing to disburse the entire outstanding claims, whatever are the claims.
Lord, the
for 10
total
and a half lakhs.
outstanding loans up to date with interest works out to 12,56,645.
12,56,645.
It is with interest note.
Willing?
Milords, we are willing to pay that amount.
Oh, within what time?
Milords, you may give us 1 month if possible.
1 month, okay. Mr. E.C. Agarwala, Learned Counsel, appearing on behalf of the state of Uttar Pradesh, has at our request taken instruction and has submitted before us that the total outstanding is rupees 12,56,645, including interest. He would further submit that if this amount is paid within a reasonable time, the possession as well as what? Leasehold rights, right? Or ownership right? What is it?
Milord, this
Allotment,
would be
no?
This would be a license, Milord. This would be a
License, possession with appropriate license.
Yes,
shall be granted in favor of the petitioner. Full stop. In view of the Mr. Shreyesh, to two shops with respect.
Only one
46
shop.
and 40, only one
47.
shop. 47. One is already with you.
Milord, the 46, what they've done is they auctioned it off. I challenged it
You said
separately
you
where
gave
there's a matter is pending in the High Court.
47 with respect
47.
to shop number 47.
47, Milord.
Okay, Mr. Shreyas Lalit on instruction says that his client is willing to pay the said amount within a period of 1 month from today.
Yes.
In view of the submission, this appeal is allowed. Judgment and order. In view of the above, this is a 32 petitions. In view of the we allow the appeal, set aside the judgment and order passed by the High Court, and direct that the license agreement shall be confirmed in favor of the petitioner upon payment of rupees 12,56,645 645 within, give us a date. Tell us by end of February.
Yes, my lord.
Right, so and so last date of February 2027. That's a New Year gift he gave you.
Yes, my lord. I'm very grateful for that.
Thank you, Mr. Agarwal.
Grateful.
With these directions, this special
on behalf of the
civil appeal stands disposed of. 46.
My lords, on behalf of the state, my lords, we will be putting in our reply today. I know we have been a little remiss, but we will be putting it in today.
Okay, at the request of
Last
the
opportunity to
state,
be given, but it's okay. That's
filing a counter affidavit adjourned by 4 weeks. List of 4 weeks. That's it.
Well,
Next.
rejoined for 2 weeks, my lords. So the lordships may also consider,
Seven.
because they have not challenged the 9-1 order, which is the impugned order, has worked itself out. That is also going to be
You tell us.
very
We will take.
obliged.
It's a reversing judgment.
Lord, in item 47, I appear for the petitioner, Lord. Here, the decree was obtained against the person in whose...
We've been litigating from 1959.
It's a reversing judgment.
My lord,
What can be done?
Your lordships have already issued notice. They have not filed any reply so far.
Leave granted.
would my lord, may I say this? We are litigating from 1959.
You settle. In the meanwhile, you want to settle, we will refer to mediation.
My lord,
But
my
Lord, they
lord
are
may also
actually
indicate a
completely
date on which this
strangers.
case will be
They are
taken.
complete strangers to this litigation.
Sorry?
They are complete strangers to this litigation because I had obtained a decree against the persons in whose favor I have not executed the sale deed. They didn't come in appeal. They have not even challenged that appeal. How can Lord the appeal court set aside a decree in my favor at the behest of somebody who's having a separate independent right?
Right.
So
If
your
my
lordship,
friend wants to
I
argue,
would
we
not
have no
beseech
problems
your
with
lordship.
it. So my lord is granting leave. All I'm saying is let the hearing be expedited. Some date may be
And
fixed.
of course, I will join my friend. I also want Lord the hearing.
Would my lord indicate a date, my lord? Otherwise, it will not be 10 years is
Final
gone, my lord.
hearing,
We started
Balaji,
at
you know.
59. My lord, I'm
The final hearing, there's no
my lord, it started in 59, my
He
lord.
said hearing expedited, Balaji. Yes, you should
And my lord may also indicate it's a short matter because there's the rule which says short matters have to be listed at the earliest.
48.
As per office report, my service is yet to complete, Millers. This container may be served through police station, Millers.
You take possession anyway. Have you taken possession?
No, I have to get the status regarding execution, Millers.
Has he filed an undertaking?
I have to check, but to my understanding, there is a rule they have not supplied us a copy, Millers. But a statement was made before, my lords.
Nobody is appearing. No. We have said that you should take possession. We have already specifically directed.
Office report says
we direct so and so
Yes.
judge to ensure that the contempt petitioners are put back in possession.
Kali put it after 4 weeks. In the meantime, I'll apprise.
We gave an order in your favor.
Very well, Miller.
What do you mean very well?
But that had not been done as of now. We have yet to get the status.
You have to go and we said that we can't initiate contempt because they have not filed an undertaking here. So we will dispose it off in terms of our order, get it executed, and then get back your possession immediately. We have said specifically.
Yes, may I request, I'll put it after 2 weeks, Miller. In the meantime, I'll get
Just
the
after week.
Very well.
No vacation karke mat likhna. Yes.
Obliged, Miller.
I am further respondent in this matter. Counter has been filed. I might need to rejoin. Lordship can fix the date. There is that case where Lordship has granted a stay. Habitual absentee.
What is their run?
Well, from 2006 onwards till 2008, she was on leave. Then we tell her to join. She was acquitted. She does not. She says, "No, I want to seek
Lordship
resignation."
Normally, in the some heat
But
of
till
movement,
2007, she does not even file a writ petition. From 2011, apparently she makes a request of VRS. Then 2017, she makes a representation and files a writ petition. The writ is allowed on full terms.
Doesn't matter. It is a livelihood employee.
No, that's not how she says. She resigned. She resigned.
That
It
was
was
withdrawn.
accepted.
That was withdrawn.
It was accepted.
May have resigned.
Even Tarsem Singh says, my lord, 3 years. They are relying on Tarsem Singh. It says only 3 years she has not worked for a single day. We'll file a rejoinder to this effect, my lord.
Before it could be accepted, she withdrew it.
No, that's what she says. But it was accepted. Then
You have also
give me
page
VRS.
79, have a look.
No,
You have
I know.
submitted it.
Lordship will kindly come to after.
Page
Okay, later.
79.
There's a procedure of the rules. Lordship will kindly see.
There is all. That's the man, somebody in a long tenure, she suddenly of heat of
No,
moment resigns.
2006 onwards, she's
That's what-
off. She's not working for a single day from 2006. And look at a conditional acceptance of.
You accepted the.
No, then Lordship will come to page 48, 65, sorry, running page 65, PDF. Now, VRS page 67, sorry, PDF 67. After that, she says, give me
What
VRS.
did you argue for us to issue notice and
The fact that she never worked for so many years and
From when?
the
From
writ
when?
was filed. Lordship will kindly have the date. From 2008, in fact, earlier there was from 2004 to 2006, she was on absent from duty. There was a disciplinary proceedings initiated.
she rendered, when did she join?
In she did not join.
85.
85 she joined.
85. Girl, yeah. Girl or a boy?
Girl.
Rinku is.
She's a lady.
Woman.
She's a lady. She's a lady.
88 to 2008.
We worked. 2004. After that, disciplinary proceedings started.
She rendered.
Yes. And what happened
Because
was,
of medical leave.
on 2008, when she is actually relieved of the charges,
20
we
years.
tell her to join. She says, I want to resign in 37/2008.
She gave her
Resignation.
resignation of 30th of July.
That's right.
And then withdraw.
And then
threw it on 19th of February. This fact you admit at page 79.
But
then he accepts resignation on 30th March. You
Yes, sir.
accepted after
Resignation. was
after 1.5 months.
the withdrawal was not according to procedure. That is our stand.
She says that at least give me VRS.
VRS, that's right. And then
she sent her sent to.
she's not
Either.
VRS also. There has to be a scheme. Now she writes
Notice.
that on 9/9/2009.
Or release interviews. No.
And Malas, then a representation made in 2011.
Not a case.
No, but then
I don't
how
think
do I pay her the entire back page? Look at the way and High Court.
Whatever you do.
No. Lordship will kindly have the High Court impugned judgment. Last paragraph.
Okay, last portion.
Last portion of the impugned order and read the single judge at page 98-99.
That's not work.
High Court in my appeal also adds 6% interest. She has not worked for a single day. Your Lordship hold.
Find no reason to interfere with the file.
That's right. And then and page 98-99 is a single judge. Lordship will have 98-99 for a minute.
She worked with you for such a long time, Rana. Don't be so unfair to her.
No, one can. No, but a lady who is not willing to work at all. I mean, Tarsim Singh says 3 years. So Tarsim Singh. Yes, Mala. Look at page 98. However, may I read this, Mala? Taking into consideration the fact that the petitioner was in regular service from 85 and has also been found by this court that acceptance or resignation of the petitioner by letter dated so and so is erroneous based on settled principles of law. Then the direction to pay was directed to release pensionary benefits, gratuity along with all other admissible benefits.
Earlier, actually, you've been unnecessarily. High Court gave more than what we will reverse this against you. It may have been argued.
The impugned judgment. They've added 6% in.
Has not been acted, which is.
But from 2011 to 2017, she does not even report for duty.
So
she can say that I have gone there. Just a minute. She can say I've gone there. They did not allow me to join. She does not do anything 2011 to 2017.
No, they didn't give back. Thank you.
No, Lordship, can you see this?
Rana, you're not going to interfere with this.
Lordship, the impugned order for the minute. Last paragraph. They've also added 6%. Now we do not know how to work this out, Malas.
You can easily work it out. No problem.
Here, Malas. Last paragraph. Page 35. You have modified the impugned judgment to an order to the effect that appellant should also pay interest. Now, this is a premium on someone who doesn't want to work. Why should it be out of pocket? And Tarsim Singh, Lordship, last paragraph says
6% is
2008, Lordship will have 2008.
Okay, thank you. Dismissed.
Well, Tarsim Singh
Item
says
51.
3 years, my lord. 3 years.
Nothing.
Very.
50.
I thought 3 years would
Kunal is looking.
Kunal is looking cross at me.
It will be on me because the rejoinder has not been filed.
Thank you.
Thank
you.
Its notice has been issued, counter has also been filed, my lords. The issue, my lords, is whether we fall under the exception, my lords, under section 3, subsection 2, clause.
Whether applies or not.
Applies or not. That's the issue, my lords. The issue, my lords, is there are 13 plots Our case, my lords, is we've always considered 13 plots, my lords. Now, the issue, my lords, is there are 13 plots. Our case always has been, my lords, that the 13 plots have been separately developed. If the 13 plots have been...
Who are you exactly? You are the...
My lords, I am the builder, my lords. I am the builder.
Why won't RERA apply, not apply?
My lords, if my lords may show section 3, subsection 2 clause A, my lords, it provides that if the area of the land to be developed is less than 500 square meters, or the number of apartments to be developed is less than 8, then the requirement of registration does not apply, my lords. There are a series of 13 plots, my lords. We develop... If 13 is taken into consideration, my lords, it will cross the threshold. If it is taken individually, my lords, it will be within the exception, my lords.
Picture of that? You have photograph somewhere?
Yes, my lords. Lords, you put them on record also, my lords. I'll hand over photographs. Yeah, the photograph.
You have developed it as a common thing, right?
No, my lords. Let me explain what happened, my lords. My lords, I'm a builder based out of Neyveli. The respondents, my lords...
Neyveli,
my lords, in Tamil Nadu. The respondents, my lords, are lower cadre employees working in the Neyveli Lignite Corporation. They reached out to me, my lords, asking if they can build plots or provide flats or apartments for them in Chennai, my lords. So I come up with a scheme, my lords, taking into consideration their financial capabilities and constraints, saying that in a plot of 1,540 square feet, I will build 4 apartments. So it was always conceived, my lords, in a small plot, 4 apartments. Others came, therefore...
It's a scheme.
No, let me point, my lords. The point really is, my lords, it was done specifically for them. Idea, my lords, was one single plot of 1,540 square feet, my lords, which is less than the 500 square meters.
How much is square yards? How many square, the land?
My lords, the area, my lords.
You took
1,540 square feet, my lords, which will be 143 square meters.
To build 4 flats on each plot.
And 4 flats, my lords. So therefore, both the requirements will fall in.
You took 13 plots.
13, my lord. In fact, what happened, my lords, because they came and said, I need this kind of a requirement, there was a larger plot of land, my lords. I had specifically subdivided those plots. If I was really, my lords, developing one single project, there was no need, in fact, my lords, to actually subdivide the plots. Larger tract of land, I divided the plots, my lords, into 13 separate plots so that I can give them this. I don't just do that, my lords.
We are inclined to take the view that you should come within the regulatory regime of RERA because it has to be considered as a holistic. It can't be, yes, and it fails imagination to...
My lords, the purpose, my lords, I appreciate what is falling from my lords.
Bits and pieces. You can't cut it into bits and pieces and say they are all individual plots.
No, my lords, in fact, it was actually subdivided, my lords, as separate plots.
250 apartments together.
My lords, it was actually, for them, it was only 52 apartments, my lords.
For them.
Let me just point out, my lords, therefore, it was actually 13 separate plots. It was actually keeping in mind their requirements. Had it been the case, my lords, that I actually wanted to develop a larger real estate project, there was no need, in fact, my lords, to actually subdivide the plots. I don't just do that, my lords. After I subdivide the plots, I actually sell the land to 4 other persons. So therefore, it is taking into consideration the requirement that in a plot of 1,540 square feet, after that, my lords,
I will tell you, you are looking at it from their perspective that they were only a small segment. But the law doesn't do that. What we will look at it is that what is the project that you have undertaken, and yours is a larger project consisting of 13 plots you clubbed together, and you have undertaken a large project. Only they might be owners with respect to only a small segment of it. That doesn't become the reason for excluding from RERA.
My lords, I may just, my lords, draw my lordship's attention to section 3(2)(a) just for a moment, my lords, because it depends upon the area that is being developed.
Prior registration of real estate.
Yes, my lords. If I read out, my lords,
3(2). RERA rules, no? Definition of ongoing project and promotion.
Yes, my lords. Lords, those are other points, my lords. First point is on this, whether actually fall within the exception. And the question is whether I'll become a promoter, because what happens afterwards, my lords, the land is actually sold to them much before, my lords. In 2012, RERA comes into force, my lords, only in 2017. After 2017, my lords, my role is only actually as they are the owners. There is a construction agreement entered into. I am required to construct. The question, therefore, my lords, is also whether I'll become a promoter. So those are subsidiary issues that come up, my lords. First issue over is, my lords, whether under section 3(2)(a) I fall within the exception or not, my lords. My lords, may I have a look at 3(2)(a)? My lords, I appreciate what is falling from my lord saying it's a
statute.
My lords, I appreciate my lords, but this is not something that was done after RERA came into force. My lord.
Concern today. Why are you fighting? What's your concern today? It's only one of a project. It's not going to be again for you. It's only a theoretical.
No, my lords, there are
What's
other
the problem?
implications
What's
that
the
will follow, my
problem?
lords. Once RERA comes in, there are other obligations.
Has to come in.
My lords, which is why, my lords,
Has
our
to
submission
come in.
is.
It's an act which will protect consumers
My lords,
and protect you also sometimes.
my lords, I appreciate what is falling, my lords, but my only request, my lords, is the rigors of the law have to be necessarily complied with, my lords. If I'm otherwise falling under the exception under 3(2)(a),
You expect Supreme Court to
my lords,
take you out of law.
no, my lords, my lords,
Then will not interfere. Thank you.
my lords, may I at least make another submission, my lords, insofar as the promoter is concerned. The question also, my lords, the obligation falls upon a promoter under section 3(1), my lords.
So?
Promoter, my lords, is, if you look at the definition of who is a promoter,
Whatever is the law, will apply.
my lords,
And
the
regular-
submission, my lords, is whether I'll be a promoter, my lords, because these agreements, my lords, are entered into in 2012, my lords. Land is already given to them. They are the owners of the land. Ultimately, what I'm required to do, my lords, after RERA comes into force, is only construction. There are construction agreements that are entered into. Question also, my lords, therefore, whether I'm a promoter, because section 3(1), my lords, places the obligation upon a promoter. They are the owners of the land. I'm required to actually construct now the buildings on that, my lords. So whether the obligation under 3(1), which is on a promoter.
You explain, but then this is only confined to whether the regime applies or not. Nitty-gritty is whatever you say. Thank you. Dismissed.
I'm grateful.
Much obliged, Mayor.
Much obliged.
Lordships had been kind enough to issue limited notice in the matter, my lord.
Against order to vacate.
My lord, it's in a writ proceeding.
Vacating is something.
Lord, separate proceedings for eviction is.
Those are pending. You will only modify that portion of vacation part of it. Yes, tell us.
But the gym is still continuing, man. Despite our notices, the gym is still continuing to function. I mean, whether he
That you
vacates or not
stop.
is
That
between-
you get it stopped. You are running the gym.
Lord, my instruction.
You can't run.
We
He has
are
got
in
24
possession, but
criminal
we are not
cases.
running the gym.
Yes,
That's my
Satyam.
instruction.
But he is an element who has got 24 criminal cases against him. Very bad man. And he is running it. my lord.
Very bad man.
In violation of.
My Janet Senior will confirm that he is running it, man.
Yes, he is running. He is running, my lord. Despite
You
24.
are for whom?
But I am for the landlord.
Landlord. Who is
Complainant.
the state?
Complainant.
Corporation? Stop him. Why are you telling us?
Because it's pending here, but
Go seal it.
He has got no regard.
Go seal it.
pending before this court.
But so far as High Court's direction is concerned, not to be evicted, except according to law. That's it. Isn't
But
it?
there is. Already there is an eviction order in our favor.
That's an interim measure.
There is already an eviction order in our favor, passed by the competent court. Despite that, my lord, he is running. Therefore,
You throw him out, I say, through your legal process, but in a
Correct.
matter relating to a writ petition filed against the gym, you can't evict him.
I understand that, my lord, but
What do you want us to do?
my lord,
Exonerate so that you will take action?
my lord, no, 136 jurisdiction. My lord, let him not have the benefit of running the gym, my lord, in violation without any permission, without that. That direction, Lord, may be pleased to give.
I sent notices twice, man.
He is running.
See our order, it's very, very clear. We didn't even permit him to run the gym.
But he is doing, my lord, that's what we are saying.
Then you stop him, sir. Why are you asking him? You stop him. Ask corporation is next to you.
Because it is pending this.
Just seal his gym.
The Lord me just put that observation, man, because the officers are little tepid because it's pending before this honorable.
We can dispose it off also. Okay. In continuation of our order dated 18/8/2025, we had, and this is to clarify that we had only directed that directed stay of eviction as per stay of eviction, full stop. However, we make it clear that so far as the running of the gymnasium is concerned, there is no embargo against the corporation for taking action against the respondent.
But this may be disposed of. But we may be given liberty because we already got an order of eviction from the rent controller. But we will work out our remedies there because of the pendency of this, my lords.
Against the petitioner. इसमें अब रखने का जरूरत है. Is there any need for us to keep this here pending?
Because rent control proceeding we initiated for eviction order in our favor, he has filed an appeal. That matter could not be taken up because of the pendency of they cite this. Therefore, this may be disposed of, giving us liberty to work out remedies to evict according to law.
This arose out of a writ petition, right?
Yes.
In which he challenged 10-12-24 order.
Yes.
My order.
Where the notice was issued about sealing of the gym. Leave granted. The specially petition is arises out of a notice that has been issued on 10th December 2024 to the petitioner herein 10th December by the Assistant Commissioner warning him that the property would be sealed if the petitioner runs a gymnasium without a license. Full stop. This order was challenged by the petitioner before in writ proceedings.
WPMD 920.
Single judge dismissed the writ petition. However, while disposing of the writ appeal, the High Court passed the following order. वो quote कर लेना. Para 10, para 9 and 10, 9 and 10 quote कर लेना.
10 Malad.
9 and 10 full stop. While issuing notice.
Municipal Corporation Act and then I'm already plugged in.
Yes.
10, 12, 24.
Eviction order.
Case and directing eviction. Is the appeal pending against that?
Malad.
Is an appeal pending against that?
Rent control appeal is pending, Malad, and separate EP is
also informed that an appeal against the order dated 29/11/2024 is pending. So we make it clear that eviction of the petitioner will be subject to the outcome of the rent control proceedings. Full stop. With this, we'll also, in this view of the matter, the direction in paragraph 10 is set aside. Full stop. We also make it clear that the commissioner will be, the municipal corporation will be entitled to seal the premises in the event running the gymnasium is against the rules and regulations.
Great.
in accordance with law only.
Yes, everything is according to law.
Obliged.
Plus, I have filed my counter.
I'm item 52. I'm seeking 1 week's time to file my rejoinder affidavit.
Okay, have it after.
And Malas, I am filing an application seeking permission to file additional documents. And
we'll have it after some time. Then you file it. You file that up. You have the application been filed or not?
Yeah, no, it's ready. I can give it to you.
Yeah. Additional document already filed.
No, to be. Yeah. This is an application seeking permission to file.
Yeah. Okay, all right. Whatever it is, you file it. Whatever it is. Application for additional document is permission to file additional document is allowed. List after 4 weeks. In the meanwhile, you exchange whatever.
It's only 1 week rejoinder affidavit. 1 week's time may be granted because if it's not in the order, the registry will not accept it.
I mean, rejoinder may be filed within a week's time.
I'm grateful. Can it be a fixed date? A lot is an 89-year-old lady.
We'll give it.
Any fixed date.
Fixed date. Next.
I'm grateful.
Which day?
63 mallots have directed adjournment of similar matter mallots to await decision in 24787 mallots.
Lordship, item 53, I'm appearing for the state.
We are appearing for the very first time to them, seeking 4 weeks time to file the count. 53, Your Lordship.
My Lords have in fact adjourned them. I have no problem, my Lords, if they want to file a reply. My Lords have in fact said that, my Lord.
Why a 32?
It's a transfer petition, my Lord.
30p?
Please, my Lord. My Lords, that I have adjourned similar transfer petition. Same land, my Lord. There were 2 landowners who had filed 2 TP, my Lord. I have indicated on that day that we will await the decision of that.
Same order, same order.
My Lords have said that I will not ask for a reply. Please,
Lordship, liberty may be granted to us to file reply.
please, ma'am.
Obliged.
May I please your lordship? Lord, pursuant to your lordship's order dated 3rd of November, my lord, permitting me to participate in the counselling, my lord, I approached the state, my lord. The state said that this one seat which was kept reserved pursuant to the single judge's order was immediately filled up, my lord, after the division bench's order. Therefore, my lord, there was did not permit me to participate in this counselling.
What can be done?
So now, my lord, the
Structures.
The counselling has become, but my lord, here this is a completely illegal. Illegal.
All right, we will see. These are all last moment matters. If we can help, we will do it. Otherwise, it's not a case for.
My lord, it's clear infraction of the central government's policy, my lord.
We'll see later. Dismissed.
My lord.
We'll dismiss it now. There is nothing we can do about
Lord, lordship may kindly, my lord, hear me then on merits, my lord.
What do we do at this stage? What relief can we give is what we are saying.
Lordship can give me a admission in a seat can be my lord, reserved, created.
Where
as your lordship has passed.
Everything is over.
This is totally illegal. Absolutely illegal.
Everything is
why
over.
your lordship issued notice.
Can anything be done for him?
Well, it is, the whole petition is infructuous, and the central government has affirmed that what we have done is in accordance with law, and they are not entitled to under the category of the state because of the poor medical infrastructure.
Only we can do one thing. We can just see the question of law so that it may not arise a later point of time.
Well, lordship may
assist us. We'll put.
I will, my lord, because this is a completely illegal, my lord. And by the state, the circular is contrary to the central government's notification.
All right. Okay, list
a
for
short
hearing.
date, my lord, in
List
January.
for hearing. No interim order, list for hearing. In view of the question of law. Doesn't matter. Just adjourn on a final disposal के लिए कहीं date दे देना.
And the ministry also may be directed. They are party in this.
You don't make the ministry a party. Have you made?
Yes.
They also have to.
Serve on
They
them.
have been served also.
They may be directed to file a reply.
They are on record. Unlike, my lord, what my learned friend says, they are on record before the High Court saying that this circular applies to me.
It doesn't.
Lord, it's a totally illegal action, but your lordship will consider.
He can't sit in judgment over the policy.
Obliged.
My lord has noted central government also.
We will issue notice has gone, so let them come. They will enter apply.
Very well.
Lordships 55 on seeking a passover, my lords. I'm led by Mr. Devan.
Which one?
Item 55, my lords.
Then would you
That's a
lordship
short
have it
passover.
after the vacation month, after recess?
Contempt.
Devan is there.
My lord, this was the matter where your lordships have kept it because the question was this. When
I'm only seeking a short passover.
When a transaction is done, no, I'm not arguing it. Lordship was saying, what is it? That's not. When a matter is in violation of an order, whether a court in contempt.
We will list the matter for a disposal.
Please, my lord.
So vacation लगा दें. Next.
Lordships, please.
You can fix a date in this matter?
Yes, we will fix a date.
Lord, this is that contempt in that Calcutta teachers matter.
He's held up.
Yes, Kunal, what is to be done?
Gupta is leading in another court.
What is to be done?
Lordship may pass it over now.
Lord,
I'm appearing for the state.
They have filed an affidavit, my lord.
Vacancies from the state. We have filed.
Because, there is a problem, Lord, which I wanted to indicate, and I seek some indulgence from your lordship.
What happened? What's the difficulty now?
The difficulty is, my lord, that
56.4.
File the counter.
I have filed a counter.
Have you seen it?
I have seen it. The board has filed a short affidavit. Board says we are writing to the government that in this Bengali.
Who is appearing for the government?
because I am appearing for the government, your lordship's indulgence digital.
File a counter to tell us what exactly is the problem.
Lord, sir, the problem in this case is, Lord, that because of the earlier interim order passed by this court, Lord, large number of vacancies had already been filled up. So now we seek your lordship's permission, Lord, to create a supernumerary post, because unless that is created, Lord, these people cannot be accommodated.
Difficult. Easily the vacancies.
That may not be right. There are 11,000 posts
Correct.
of which there are only 2,800 which are.
Ask your secretary to come. I think you are trying to evade it. Huh?
Yes.
We are getting an impression that you are trying.
Yes.
That page 87 of the. Avoid. We'll give you the last and final opportunity. We'll list this matter immediately after vacation. In the meanwhile, file an affidavit.
And respondent number 4 is the second.
Do that.
We have filed.
No, I'm saying state.
Respondent number 4.
But the Lordship may also observe, Lord, that if need be, we can create supernumerary post notes.
You do whatever you want. You comply with our order.
But without your Lordship's observation, my Lord, it will not be possible.
They are just trying to be difficult, my Lord. There is nothing.
There's no need for any observation. If you want to comply with the court's order, it is a legitimate obligation on your part.
In fact, on the last. So, an observation will help us.
Order. If you need to do it, you do it. What prevents you from?
My lords would recall when the last contempt was filed, my lords had said it was only about reappropriation.
Who is my friend appearing for?
And for the original respondent.
He is nobody in the contempt. He's not a party.
I am the one who's appointed in the interim order.
He is not a party in the contempt. These are all people to clear the pitch. They are trouble. Yes, yes.
We will list it in the first week of January.
Correct.
Mr. Dwivedi.
My lord, what is happening is.
You good that you have come in now. See that. Tell the government to comply with it.
Lord, the government is ready to comply. We just wanted an observation.
Do that. There is nothing, no prohibition with respect to what you want to do.
And we just indicate, Lord, that if need be, my Lord, state may create supernumerary posts for that.
The state shall take such steps as may be necessary for complying with the order of this court dated 4th April 2025.
May I interrupt, my lord? May I interrupt, my lord?
In the meantime, what has
my
happened?
lord,
They have started a fresh process.
an IAS matter, my lord.
Not do it.
In another matter,
Don't expand the.
All right, then your lordship may just
Expand
post
this
it in the first week, my lord. Let us see what happens. Yes, grateful.
Grateful.
My lord, your lordship may say, failing which he will come.
We will do.
All right.
The Dwivedi is there.
All right.
It will be done now.
Carry the cross.
All right.
With this observation, it will be done.
All right. I take that.
Grateful, my lords. Deeply grateful.
Grateful.
My lords, I appear for respondent number 2. There's a letter circulated.
Just for the letter.
I'm seeking time for the counter.
58.
Most shocking. These people are incorrigible, the administration. What happens, Malaj, in the previous year?
This we don't know.
I'll tell you, Lordship. In the year 2000.
Who is appearing? This is the
Supporting petition.
Sunit Narang.
I'm not supporting it all.
Stuti Narang.
I'll tell you, Lordship, in a nutshell, Malaj. In 2024 batch, this honorable court, in line with other judgments, said you can't have postgraduate reservations based on residence. There, Malaj, they had 5 years of schooling.
Batch has already come before us.
No, this is that matter. Now, Malaj, what they do.
May I speak, my Lord? If your lordship.
So, Malaj, this is the order part. The matters refer to 3 honorable judges. They said it is covered by a constitution bench and they say no reservation on PG. The administration files an application for clarification, dismissed with costs. Now, in the next year, they again reserve on residence, Malaj, that you should have 10th, 11th, 12th. And the same thing has been struck down in Vishal Gupta, Kriti, Lakman, series of judgments. They are incorrigible, Malaj. They've suffered costs and they're back with the same prospect. And the High Court has struck it down.
Now, new matters which are getting filed. We have some more fresh matters which have come.
I'm not aware of that. I'm aware of this one.
Here there is one difficulty.
Well, Lord, may I, with the Lordship's permission, address I was the petitioner, my Lord. Lord,
Yes.
he's just overtaken me completely.
Oh, we didn't see anybody there. I'm sorry, I didn't see.
No difficulty.
Yes,
Lord,
Mr.
the
Diwali,
issue
tell
is,
us.
yes, Lord, the issue is twofold. There are 2 questions, Lord. Number one, whether quota on the basis of education is by dissent, as the High Court says in paragraph 24, my Lord.
Good judgment.
And secondly, my Lord, in the 3-judge bench dealing with this very college, your lordships have held that if the UT pool is, if the 50% seats have to go, they have to go to the all India quota. They cannot go to
I've just
institutional.
entered. We can put in a reply. We have to respond in 5 minutes.
There is another.
Someone not
Lord,
served
the
also.
admission will take place tomorrow, my Lord. That is why your lordship had given only 3 days. Tomorrow is the date for admission, my Lord. Otherwise, this petition will become infructuous, my Lord. And then what will happen is ultimately, even if your lordship find that this appropriation towards the institutional preference is wrong, your lordships would be constrained to allow the admissions to go, because that is what happened in Tanvi Behal last year at page 19. Your lordship may kindly see that judgment, my Lord. There are two issues, my lord. If the High Court says,
what is the interim measure that you?
I am for the student. I am for the student, Millet.
Mr. Gupta, may I just address the lordship
putting
on
a
what is
query to
interim measure?
answering
My lord, 50%.
Tomorrow we'll pass orders, Mr. Tiwari.
Very well, my lord.
Tomorrow we'll hear. All of you get ready.
Item 59, there is a delay of more than 490 days.
Milords, I'm seeking some time.
Which
the
one?
Arguing counsel.
59.
59, there is a delay of more than 490 days, Lordship. 26 years we are struggling. Respondents are more than the age of about 75 years, Lordship. They are already rendered about 28 years of service.
Milord, it's a summary court, summary general court martial proceedings matter, Milords. It needs to be heard.
Yes, it needs to be heard. Why not? वो तो सुनना पड़ेगा ना?
Yes, Milords.
Is it been admitted?
No, Milords, it's not admitted.
Not admitted, Lordship.
We'll have to admit this.
Lordship,
Final order, yeah. It's against the final judgment. Leave granted.
Directions, Milords, is listed for directions today. It's listed for directions.
Why?
Lordship, we have.
Why is it listed for directions?
Lordship, we have mentioned this matter because the respondents are more than 75 years of age, and it is 26 years they are struggling in the litigation, Lordship. They have rendered 28 years of service. After 28 years of service, they
listed
were
in January,
dismissed
Milords, we
from
can
service,
ask.
Lordship.
Immediately after vacations, it may be listed back.
Okay, list on non-listed.
Lordship requesting for a fixing the date, Lordship.
Yes, yes, we'll give a date. Then February, maybe then update. So how long will it take?
For me, it will take around 15-20 minutes. I do not know how much they'll take.
It will take some.
Because it's very clear in the judgment, Lordship.
Competitive property show car.
Milords may list it after the vacations, Milords.
Partial to conviction and charge. Hearing to lagega.
It will take about a hour for the
Urgency. What's the urgency? Is retired and
They are retired in 99, Lordship. Since 99, we are into the litigation, and now our age is more than 75 years of age.
how many of you are here?
Lordship,
four respondents, Milords.
four respondents.
Hearing expedited kar lenge. Leave granted, hearing expedited. List in the month of March.
Much obliged.
We'll do it.
Praise the Lord.
May it please you, Lord. Your Lords, I appear for the petitioner in this. My Lord, this is infructuous now to that extent because it was going against a disqualification. He has been re-elected.
Yes, correct. That's how it got listed. Dismissed as infractions.
My Lords, may kindly record upon instructions.
Upon instruction.
Hey, my Lord.
Submitted.
Deeply obliged, my Lord.
Dismissed as infraction. Thank you.
My lord, subsequent to the election in challenge, two more elections have taken place. If today the order of the High Court is upheld or that has to be followed, it will be an infructuous exercise by the prescribed authority.
Actually, everything is also, even the time is also over.
Yes,
now.
so my only submission is that the order of the High Court will be set aside and the situation may be put as it is because there will be no fruitful purpose will be served by going back to the prescribed authority and telling him to relook into the matter.
We'll just say it's become infructuous now.
But my lord, the order of
notification been issued.
My lord, I am appearing for respondent. R6, R7.
No, my lords, this was pertaining to election of 2014. In 2019, another election took place. 24, another election took place. The committee has all changed.
My lord, my submission in this regard, there is some unanswered legal errors that they are carrying over. So the High Court has only remanded this matter.
26. The order this
discretionary to seek to rectify the legal error.
5.
And to ensure a complete and fair adjudication on the part of competent authority. High Court in exercise of jurisdiction under the Honorable Court under Section 136 of out not to interfere with the non-final recent order, remand order, particularly when High Court found the flaws in the previous authority.
And my lord, even on merits also.
So my submission in this, please. My submission in this regard is that, so please dismiss the SLP and allow the fresh adjudication on the matter which is unresolved and
all right. Just please wait. Just jumping in and then talking. We didn't even commence the petitioner from hearing.
So, my lords, even on merits also, there was a non-compliance of Section 25 of the Societies Registration Act. Only one member filed an application before the registrar, who on because 1/4 of the total member have to file a complaint or application. Only
My
one,
lord,
he has also died. In fact, his rights are no longer existing.
my lord, the 25 deals with the election, not with the adjudication of the issue
Yeah,
other
the
than
passage of
election.
time will take care of it.
Very well, my lord. That is the only thing. The
Just
high
we-
order of, because
we
first
will
in
just
first
not interfere. That's all. Whatever it is, in the meanwhile, if the decision is taken or not taken,
Like 2 elections has already been taken place after that.
My lord, but what will happen is that the prescribed authority will go back and have to reinvestigate, and everything has to be done. They'll have to call upon the old members.
in the meanwhile, election notification. will-
Election, etc. 2 times election have taken place, and they have not challenged the
taken place.
subsequent elections also.
So then the only way we can say it is that it has become infructuous.
But my lord, then the prescribed authority, the order of the High Court has to be set aside.
What do you say?
Yes, my lord, my submission in this regard is that still there is some issues which has been raised by the
Elections have been had twice over. Correct.
So in this case, my submission is that
Third,
this
yeah,
issue is
to the
liable
third,
to be dismissed.
2014 to 19, 19 to 24, 24
We'll
to
just
20.
clarify this. The directions, in view of passage of time, we are of the opinion that the directions issued by the High Court, the prayer in the writ petition has become infructuous. You are of the opinion the prayer in the writ petition has become infructuous. In this view of the matter, the special leave petition need not be interfered with. That suffice.
And my lords may clarify that there is no need for the prescribed authority.
When we said that the prayer in the writ petition has become infructuous.
Lord,
Prayer in the writ
a
petition.
small
as well as
clarification,
the-
because they
as well-
My lord, one submission.
Yes,
that
yes, directions
this
may be-
this doesn't require interference in regard to the through SLP as far as the order of High Court is concerned, because the issue is still unresolved. With certain issue which leads to be some discovery, leads to be
No further orders
handled by
are
the
necessary.
prescribed authority only, my lord.
Further orders are necessary in the writ petition. With these clarifications, special writ petition is disposed of.
Very well,
I think all of you are satisfied with this.
Very well.
All has been.
Thank you, man.
32 petition is also infructuous now. Is it not become infructuous now?
I'm 63, madam.
62 is become infructuous because writ petition for Article 32 for not giving reservation on PWD post which was advertised in 2017. It's become infructuous, right? वो कोई है?
Lord, I'm for respondent 1 and 2, the Ministry of Education and Social Justice. The contesting parties would be respondent 5 to 9, the IITs, my lord. And my lord is right, this pertains to an issue many years back.
But then where is the petitioner? Party in person, is it?
Yes. It was in person.
None appears for the petitioner. In any event of the matter, the issue has become infructuous in view of the fact that the advertisement in question was issued way back on 14/3/2022. Stop. Next. 63.
May I please, Lord, this pertains to interpretation of a customs notification. I'll briefly indicate.
What is to be done? We have to hear this.
This has to be heard, my lord. Will not take long.
According to us, my lords, page 10 of the impugned order relies on a tribunal judgment in Patel Engineering. Identical issue, same notification.
No, that would be identical.
It has been
according to
construed in our favor. Civil appeal filed, dismissed by this court. So according to us, the issue has already been.
And that will be completely different according to us.
I will show from one line in the impugned order itself, my lord. Same issue.
And I'll tell you,
Bharya
Lord,
will not easily concede.
My lords,
I'll tell you, Lord,
not when there is a judgment
based
in
on-
my favor. On the rare day when there is a judgment in my favor, my lords, I will definitely not concede.
Exemption notice. What is the, anyway, we'll hear you.
Very well.
Want us to, you are all, both of you are ready, then we'll hear.
I am ready, my lord. It will not take long, maximum 1 hour from my
We
side.
have 3 matters to. 1 hour?
Take some time.
Okay, then post after.
Technically, it's not after notice because a delay has not
Notice
been
matter.
condoned yet. There's a
Delay need to be condoned so that
We do, it's for us to decide. How much is the delay?
120 days.
120.
plus 110 days refiling.
You can't oppose it.
I'm not. I'm just stating the facts.
Post for disposal. Wait, Tuesday में लगा देना है. Tuesday.
Whenever, my lord, any day.
Disposal नहीं. Wait, Tuesday लगा दे. Next.
Oblige.
Oblige.
MACT gave 16.5. The court allowed insurance companies.
Not MACT.
Nobody is appearing?
Yes, my lord, I appear for respondent number one, insurance company in this case, my lord. One is that there is application for delay and my lord, 465 days delay in filing the
460.
SLP.
It's okay.
Bye. And
They lost.
second,
Claim petition dismissed. Okay, admit.
Yes.
Admit hearing expedited. We'll admit your case.
Much.
oblige, my lord.
This is eviction, my lord. I've been directed, my lord, to be evicted after being in possession for 50 years, my lord, within a period of 6 weeks, my lord. The first appellate court finds fully in my favor, overturning, my lord, and
all reversal, continuous reversals.
Yes, my lord. Therefore, my lord, in fact, the first
tenant,
court
you are the tenant.
Licensee.
Yes, my lord. I am a deemed tenant, my lord. I am entitled to protection.
Still in possession.
We are still in possession.
50 years from 70 to
Lord, this entire family, my lord, has literally grown up in this house, my lord.
So what? Don't
irrelevant. That's
irrelevant facts.
No, my lord. The relevant facts
are
are
not
these.
grown. What is it?
The relevant facts are these, my lord. My grandfather, my lord, or rather the first petitioner's father-in-law was put in possession, my lord, as a licensee under a license agreement entered in 71 for a period of 11 months. During the tenure of the license agreement, my lord, he passes away. We are allowed, my lord, to continue in possession.
नहीं कुछ भी नहीं है ये कह रहा है कि I have a long uninterrupted possession in 71, complex facts relating to limitation, and then the decree was passed without adjudicating tribal issues. Well,
absolutely,
your grounds are sufficient to say there is absolutely no case.
No, my lord.
What is it that you have? You tell us some good point. You
I
tell
come
us.
to the point straight away.
What is the best point you have?
The best point I have, my lord, two best points. The first, my lord, is that I am directly covered under one judgment, my lord, which will entitle me to the protection of deemed tenancy. Because if
deemed tenancy,
that's right. If I continue, my lord, in possession as on 1973, the cutoff date, as my lord, in the position of a licensee, a person stepping into the shoes of a licensee, I am, my lord, entitled to protection as a deemed tenant under the Act.
Under which Act?
Under the Maharashtra Rent Control Act, my lord. Now, the minute that happens to me, my lord, firstly, I am
subsisting license.
That's
The license is not found to be subsisting.
That's I will address that, my lord. That is where I am covered by a prior decision of this honorable court. In identical facts, my lord, I would submit that where legal heirs, my lord, of a licensee continue in possession, and the first appellate court, my lord, has found that I have continued in permissive possession till 91. They have been accepting rents from me. After that, my lord, after some 18 years, they turn around and say that now I'm going to evict you through a suit.
71 tenancy.
So, firstly, my lord, the first appellate court finds in my favor that I am protected by the law of limitation. Secondly, they say that even on the question of deemed tenancy, you are correct. All of this is brushed aside by the High Court, my lord.
और उसको no license.
Lord, could I just show you the findings of the first appellate?
What do you say about accepting rent on that? On what ground did you lose on that acceptance?
Yeah. Could I just, in fact, the High Court doesn't deal with that. So if I can just show the appellate court's finding, my lord. Unfortunately, I'll hand it over, my lord. What happened is some pages have been missed out in the type word. Kindly, my lord, permit me to hand it over. So the first appellate court squarely addresses these issues. Your lordship may see, my lord, at page number in your lordship, in what has been handed over to your lordship, my lord.
How is the payment of rent evidenced?
I'll just show your findings.
No, it's not an oral payment. It's not by cash.
They did not even
How
pay
did
the
you-
box.
Yes.
How did you pay?
Lord, could I? I'll show you the amendment in the plaint. They don't contest that we have
That's
paid.
not the point.
So I'll be very candid.
There must be clearly the requirement of section 15. 15 is that it must be agreed in writing. Yeah.
Lord, I'll
Clauses. Laws of the license, is it?
Lord, let me put it this way, Lord. My learned senior is correct, my Lord, in that we did not adduce evidence before the trial. This is a suit by them, my Lord, seeking disposition. The burden is on them to prove that they are entitled.
Suppose they have proved their case, burden shifts on to you.
That's it. Now the trial court, my Lord, the first court, does not scrutinize their evidence. And in one paragraph order says, because their evidence is unchallenged, I am admitting the case.
So it appears that these much of facts are clear. That the license had expired, there is no doubt about. License period has expired.
Yes.
There is no doubt about it.
No doubt.
And that when they filed the eviction suit in 1991,
Yes.
the interregnum of 1971 to 1991,
Yes.
in that period,
Yes.
you say that there is a continuation of the license because of the acceptance of rents.
And that is the
But
finding.
so far as acceptance of rents is concerned, there is no evidence.
But that is the finding of the court, my Lord. I'll show you, Lordship, how
Finding
that
court
finding
is-
is. And it is also the pleading in the plaint. They cannot argue contrary to their pleading. The Lordship may see para 8 of the plaint.
Reason
Yes, ma'am.
that there is no evidence to that effect. So then what?
No.
The High Court is not wrong. High Court, suppose it had reappreciated the evidence, it's a different matter.
My Lord, your Lordships have
It's a difficult case, and you leave it at that. How much time you want to vacate? Tell us.
Lord, as I mentioned, my Lord, we've been in possession for 50 years.
How
How
much? He is very liberal to grant time. Tell us.
Always leave it to the court.
Tell us.
Always leave it to the court.
Consider 2 years. I would be very grateful, my Lord.
Subject. Ab बताइए.
Nowadays, what goes on, your lordships are aware.
So,
The minimum
you
period.
people don't vacate. That's the problem.
If your Lordship state, my Lord, we will
You don't vacate, and then we will issue contempt notices, and all sorts of things will happen.
Lord, the first petitioner here, my Lord, is she's not a good.
6 months, 1 year.
She's around. Lord, the family, my Lord, has more or less. So it is a.
Tell us.
Too high. That's too high a period. So nowadays, all 3 months, 6
The
months.
first petitioner is a widow, my Lord. Her children are dependent partly on, my Lord.
Subject to all of you filing an undertaking, and we will also make a part of our order that after 2 years, after the expiry of 1 year, they will enter and take possession, and with the assistance of police. There is no need for us to ask for any contempt petition. No. 1 year. 1 year.
And including the non-filing of
1 year.
undertaking.
You have to give an undertaking.
Yeah, that's what I'm saying. Is there ready to go to
Lord, if your Lordship require an undertaking, Lord, could I request that you have it on Friday? We have an affidavit filed.
Okay, all right. Put it on Friday.
Your Lordship is correct.
But we have concluded the arguments. Huh? You just have to
I understand.
only address on the
I would
undertaking.
be grateful if your Lordship could consider 2 years.
You better also, you can advise your client not to pursue this. They will have to execute it. In execution, you will have a whole life of 5 years. Who knows? Who knows how in our country?
Undertaking is better, my lords.
It's up to you. Put it up on Friday.
Lord, may I only request?
I just understand this actually the terms of the undertaking so that I can.
Undertaking is a standard format that you will hand over peaceful possession, clear all rents, hand over possession, and file an undertaking within 4 weeks or 5 weeks. If that is not done, automatically they will be entitled to evict you. And 1 year time will grant. There is no big science here. Sorry?
Payment of arrears within 4-5 weeks may be a little difficult.
Take more. Arrears, I don't think are much of an issue. We'll give you 3 months for arrears, 4 months or whatever it is.
I will take instructions.
They are bothered about possession.
Your Lordship may grant till Friday.
Now Friday we'll go to
Please request instead of Friday, maybe I had on Thursday, if possible.
Thursday.
Please.
Come on Thursday.
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 If it may please your lordship, senior advocate Rauf Rahim is leading us, my lords. He's in court 3 on his legs, my lords. May kindly pass it over, my lords.
Come tomorrow.
Notes,
We'll post it
in,
along with that.
in that notes, that is only on the basis of domicile.
Take it up along with that tomorrow.
All right, notes. Highly obliged. Notes.
Post along with that.
The state
item था वो अभी कल के लिए लगाया था ना 58
Item 58 was notes. Chandigarh Union Territory.
The state has also filed an SLP in support. We are both add item. May list that also tomorrow.
Yeah, give the number.
We'll give the number.
From the caveat, Your Lordship, I have not received the copy. I'm the original writ petition.
Take it.
No,
Take care.
they are on caveat. You may.
I have already served you.
Sir, please don't small issue.
Well, I will again do it.
Controversy on that.
Yes, sir.
Deeply great.
Highly obliged.
The council is there.
Not taking application. Wait, this which year is this?
We made application, my lord.
Oh,
We deposited
First
the
time is it?
money was also there.
No. This application you made for starting BFA.
No, it's only for renewal, my lord. New course, my lord. Some other course we wanted that we rejected. We are not agreed by that.
1 year course is it?
Existing course, my lord. Existing course.
1 year course is it? These are 1 year courses?
No.
B farm.
2 year and 4 year. Not. Diploma is the 2 year.
3 years and 4
bachelor
years.
is the 4 year.
Have you already got a diploma?
Yes.
So you already admitted students of
Yes, my
how
lord.
many years?
2018 onwards we have been doing. 2019 onwards we have been doing.
Is it?
No. This institute is going on, my lord, since 2019.
Why should there be a small break because of?
No. We written 7 times to file the SIA, fill the SIA 7 times. I can give the dates.
It doesn't matter. Some mistake would have occurred.
No. It's not.
They will not close their own college for just because some amount of
and
is tried to be deposited belatedly.
No. My lord, entire session has gone. Last cut-off date was the 31st of August for granting approval. For compliances and appeal for 30th of September.
When did he present? When was the last date? Tell us.
And last date was the 30th of September, my lord. For some colleges, my lords have extended till
September?
Yes, last date for granting approval.
2025.
Yes, for the academic session 25-26.
Earlier.
No.
1 minute. He filed a writ petition.
Just 1 minute.
For grant of renewal for the academic year 2025. And the High Court's direction is to consider their representation on 9th of September. And he submitted a DD of 3,54,000 along with a certified copy of the order. Just they have rejected it on the ground that the time is over.
Just see page 136.
Yes, time is over for the academic. But has he admitted students?
No.
Counseling and everything.
No. My lord, for academic session 25-26, they did not admitted any student. The running courses are there. We are not going to disturb running courses. Suppose second year
26, we are asking what is happening.
No, this college has not allotted any student.
Oh, then students.
That counseling is over.
Students are not allotted.
This year, for matter
Next year, of course, you will get it.
They applied for bachelor and diploma. We will grant.
But every year, we have to seek permission, seek extension. This year we applied for. Our money, kindly see, we deposited.
What do you want? Their students are also not allotted to you.
They will be allotted because there is a huge demand for that. There is a huge
What
demand.
be done now?
In a similar matter, you will also extend it. Because of
When was
that,
the
you
last
will
date?
to issue notice.
Last date of counseling was the 31st of October 2025.
Your Lordship's order, but in a similar matter, after having seen this only,
We thought you had admitted, Nagmuthu. Students are there, so we didn't want that sacrifice to happen.
You will kindly see, 3 years course and 4 year course, the students are already studying. Otherwise, for the first year, if there is no student.
We are not going to disturb the running
there is no student in the first year,
third year and fourth
then
year.
the staff members are to be sent out, and it will be difficult. The staff strength, we will be paying salary.
All this will depend upon whether, even if we interfere, whether you can take in students. There are no students allocated to you.
But it is because, it is pending with them. Students have not been allocated. They will be allocated.
The council.
Yes,
yes,
Pharmacy council.
Kindly see in a similar.
Can they take now allocate students?
No.
Then take it.
Entire counseling is over. Counselings are conducted by the state, not by the council.
Entire counseling is over.
Yes.
Stray rounds are also over.
Yes, all, each and everything.
Everything is over.
Yes.
They cannot do. They are not the authority who are allotting. It is the state selection committee. State selection committee has got no objection. State selection.
Why have you not served on the state every time you take?
I served on.
Where are they? Who? Where is she?
We served her.
What
Have you
time?
informed her also? She's not here.
Pass over, bring her.
Yes,
bring her.
but I will bring her.
Bring her, bring her.
Great.
May I please, your lordship. This is a matter with regard to that octroi, my lords, wherein there is an arbitration arising out of the 1940 Act. There was an award in my favor. This needs.
Sorry for the.
No problem, lords. Can it be had on a Tuesday, my lords? So, because quite a few line of decisions on this point.
Nothing we now we will take care of it.
Can we have it, my lord, after vacation?
Is it all right with you?
Very well, my lords.
Why
Immediate
after
first
vacation we thought we will.
Friday, my lords. Thursday or Friday.
I have a problem. I am going out of India.
No problem. Yes.
And therefore, my lord.
It's so wrong. Okay. Come back. This man is traveling somewhere.
Very well, your lordship.
Have it on immediately after the opening.
Please do.
डिक्टेट कर लो सर
चलता रहेगा आने वैसे से फिनिश इट
सेकंड थर्ड वीक ऑफ जनवरी
Very well.
थर्ड वीक में फ्राइडे ट्यूसडे में लगा देना थर्ड वीक ऑफ जनवरी ट्यूसडे
Please do.
Obliged.
The respondent in the first matter and the petitioner in the second matter.
Chief, I am appearing for the petitioner in the first matter, my lord. Item number 69.
Yes, yes.
My
69.
pleasure, lordship. My lord, I am for the petition in item 69, my lord.
Yes,
I beg to appear virtually, my lord.
Yeah, tell us. We will hear you. We'll just.
It can be heard to me. This was act matter which was.
Tell us. That's discharge now. We'll hear you.
Yes. Yeah. My lord, may fix some fixed time or some.
No, tell us. We are ready to hear you.
No, not today, my lord. Because the senior counsel appears in this matter.
Senior counsel appearing. All right.
Because my lord, these are released from the party. So any
no matter, we'll hear you.
My lord, I am ready, my lord.
You're for the?
I am for the petitioner in the first matter, my lord.
Yes,
If your lordship.
Okay.
What's the problem?
No. You may continue.
You tell us. We'll hear it.
Very well.
May I continue, my lord?
Yes, you continue.
My lord. May it please your lordship. My lord, my section 11 application, was rejected.
Before my learned
By
friend,
the-
may I just point out one aspect. The second matter is dependent on the first matter. If my learned friend wants to start, I have no difficulty. In the second matter, rather the first matter is passed on the basis of the judgment in the second matter. If my learned friend wants to start, I have no difficulty.
That's right. Why? How come two different counsels?
No, I am appearing in the second matter for the petitioner.
Process will be.
My lords, I'll just.
These are arising out of section 11.
That's right. So
The
section
second
11,
two
the order is passed on the basis of the section 8 order.
No, section 8 rejected by the trial court.
That order is set
First
aside by
Appellate
the
Court also dismissed it.
So I have challenged that section 8 order.
Correct.
So therefore,
that you succeeded before the High Court.
No. In the section 8 proceedings, I have failed before the High Court. So I have filed the second SLP. The section 11 order is passed on the basis of the before I had failed. I mean, before.
We know that.
So therefore, I'm just pointing out the second matter might need to be taken up. Thing. If my learned friend wants to start, I have no objection. But perhaps.
But there are two different counsels appearing for them.
I don't know, Malud. For them.
How come there are two?
No, Malud. We are because I had instruction. He may fix a date. Otherwise, he may continue, my lord.
The same
But I'm ready with the matter, my lord.
No, that's all right. We can go on. I'm just saying the second matter might need to be taken up first, is what I'm saying.
You start the second matter.
May I indicate only one thing, my lord? My section 11 application was, my lord, rejected without going into the merit of the matter. My lord, it was rejected only because of the fact that the finding of section 8 code.
Okay, you get ready because we don't want to bits and pieces. You're not already. You argue it. We will have it on the second week of January on the Tuesday. Date de dena. Tuesday, second week of January. Date de dena. We'll give the fixed date for you.
Very well.
Deeply obliged.
I'm sorry, I was only pointing out that the
Next matter will be solved.
grateful.
1 minute.
Yes.
Second week of February, January कौन सा डेट हुआ?
That's okay.
वोट खोले मिसलेनियस के बाद फर्स्ट वीक में करेंगे नहीं.
Compilation is filed 24. 13th of January, my lord. We have filed a compilation and a written submissions this Friday. Ours is also on record. Grateful.
Yeah.
Milord, I may be excused for bad throat.
Oh.
I may be excused, Milord. Milord, on the last date of
Give you a date in this?
no, Milord, I'm ready, Milord.
We thought you were asking for time.
No, I may be excused for the bad throat. That's
No, you should not.
Milord, on the last date of hearing, this argument was advanced by Mr. Dusan Deve, Senior Counsel.
Who?
Mr. Dusan Deve on the last date of hearing. When the
Item?
70, Milord.
Milord,
this case is squarely covered by Fox and Kings versus SAP India Private Limited, Milord. Milord, if you go to the order, Milord, paper book of SLP number 19853 of 2024.
Yes.
Milord, I would like to take you through the impugned order, Milord.
Shall we come back after lunch? We'll come back after lunch.
As you wish, Milord.
We'll come back. It's already 1 o'clock.
Very well.
So, must have your lunch.